Good afternoon. I'm Karen Starbowski with Mass Mutual Arizona. I am a special care planner with Mass Mutual. And with me today, I have Emily Kile, and she will be covering estate planning today as the second half of the presentation. So if you just give me a moment, I will pull up my screen. So thank you for taking the time. I know everybody's schedules are very, very busy. So I appreciate all of you attending our webinar today. So I am going to cover the 10 basic financial steps for special needs caregivers. I have to do my disclosure slide. So I am not an attorney, nor can I give tax advice. And I also have to say that Emily is not an employee of Mass Mutual, and Kile and SpecialCare, her law firm, is not a subsidiary of Mass Mutual. So today we're going to discuss the 10 steps, and we're going to talk about what's important to you as a caregiver. What goals do you want to set for your loved one with special needs? And what goals do you wish to set for your family? And more importantly, what happens when you're not around? And I know that's a big stress for many parents and caregivers. So we want to plan for the future. Many people think, well, we want to get the legal stuff put in place, all the documents, and we want to make sure we have assets, but there's a lot more to include to ensure that your child has a full, well-rounded life. You know, what medical treatments do they require, or therapies? Is there different, where are they in their life? Do they still, are they still going through school? Are they going to have further education? Excuse me. Is there skill development, job skill development, life skill development? Are they able to work? And what level will that be? Do they need that job skill training? It's really important to start early thinking about these things. Now, if your kiddo is little, that, might not make sense, but you still want to think about, employment that might not make sense, but education and skill development and medical will still make sense no matter what age your child is. And to have a plan in place with all of these items, if something happens to you tomorrow, somebody can pick up documents and know what your intentions were, what you'd like for your child. One of the big things, a big stressor for many parents is housing. So as your child gets older, I always recommend taking tours, getting an idea for what you think would be a good fit. It doesn't mean your child's going to move in immediately. They might not move in for 5 or 10 more years. But to get ideas of what you think would be a good fit for your child, so that, again, if there's an emergency, somebody can pick up your documents and go, okay, these are the types of places they were looking at. Let's go start there versus starting from scratch. And another biggie is social and recreational. That one tends to get neglected, but it's probably, one of the most important, because we want our kids to be well-rounded. We want them to continue to do outside activities, outside the home activities, be with their friends, do things, and, to have that documented so that people will know what they like to do is very important. One thing to keep in mind, when we set up a plan, ideally we're setting up for you to live a long life and, to live to 102, and and then, what's going to happen with your child then. But we also have to look at what if something happens tomorrow. So we want to make sure the plan that we put in place for you works in both scenarios. So we want to review the beneficiaries. Seems like common sense, but you'd be surprised how many times things get forgotten. When we're planning, we're not only planning for make sure resources are in place and their needs are taken care of, but we want to make sure that any benefits that they might be receiving, any government benefits that they might be receiving, aren't affected by inheritance that they might receive directly. So many of you may know that when a child reaches 18, their resources are counted as their own, and they can't have more than $2,000. And if they do have more than $2,000, their benefits that they're on could be suspended or terminated. So we don't want that to happen. So one of the first things that we do is review beneficiaries and make sure things are not going to go directly to that child. One of the there are probably two that get missed most. And the first one would be 401k plans, because typically when you fill out a 401k plan at work, they only give you one spot to fill in a beneficiary, and that typically is your spouse. Well, heaven forbid something happens to both of you at the same time. The next people in line are your children, and whether your children are minors or have special needs, they're going to inherit directly, and that could cause problems. The second thing that is probably the thing that we need to tackle as an inheritance is Grandma or Uncle Joe going to leave your child or your children money directly from their estate? Again, that could prove to be harmful for their benefits. We don't want them, if they're going to get more than $2,000, to be suspended or terminated from their government benefits. One thing that I did not mention in the beginning, sorry about that, folks, is if you wish to ask a question, there's a raise hand button on your screen. So go ahead and raise your hand. And as I'm speaking, Emily will watch that. And as Emily's speaking, I'll watch that. So go ahead and ask questions as we're going through. That is fine. So holding a family meeting. Some people think this is kind of weird, but it's actually quite important, because if you have older typical children or other family members, they may wonder, well, what happens if something happens to you? Who's going to take care of your child? So it's a great way to relay to them that you've put plans in place. It doesn't mean you're sharing with them how much money you have. It means that you're showing them you have step-by-step plans so that if something should happen to you, there's a document or a plan that they'll be able to pick up and show what steps they need to take. So super important. It helps alleviate stress, which is very important, especially if you have typical children, because in the back of their minds they're going, I love my brother, but how the heck am I going to take care of him as I get older? And so this is huge to them to understand that you've put a plan in place. This step also helps with those inheritances that might come directly, because then you can say to family members, hey, I know this is kind of awkward. I don't know what you're planning to do when you pass away, but if you're even considering to giving to, assets, inheritance to our Joe, can we make sure it's done properly? With that, you can help with a letter to give to family members to explain to them how to change and update their documents so that money flows properly. Excuse me. So creating a team. So a lot of things are going on in the life of a family who has children with special needs. We want to select team members that can all work together, all understand the special needs community, and can work for your benefit. So first step is me as a financial professional, helping you with beneficiaries and funding that trust and planning for that long-term future. Emily falls under the next bullet because she has a lot of experience in the special needs world, in the elder care world. She focuses on those two markets and does quite a few special needs trusts. So that's something to look for when you're choosing your attorney, is to make sure they have a lot of experience with special needs trusts. Accountants are a little bit tougher to find that know the special needs community. Many of them don't realize that there are different credits and credits and deductions, that's the word I'm trying to think of, that can help your family that don't pertain to others. You know, because you have a child with special needs, you can qualify for those. So that's super important. And then the other bullets are just things to make a well-rounded team so that you have your support as you're going forward. Additional resources, I always like to tell families, don't try to recreate the wheel. You are not the first family to have a child with special needs, and unfortunately you won't be the last, but there's a lot of people that have done this before you, and so look to them for help. We're very fortunate in the Phoenix area. There are quite a few organizations that can help families. For instance, SARC is a good one. The ARC of Arizona is great for advocacy. They also have group homes. Autism Society of Greater Phoenix, Down Syndrome Network, but there's also a lot of support groups. Arizona has a lot of parent support groups. They have sibling support groups, and also for the young adults with special needs themselves, there are support groups. So don't try and do it on your own. Be, looking for things and places for help. There are a lot of newsletters out there too. So, use all those resources to the best of your ability. Government benefits. So like I mentioned earlier, one of the things we're trying to preserve when we're working with families is that when they inherit those assets, when a child with special needs inherits those assets, that they're not suspended or terminated from their government benefits. So on the left, you'll see the entitlement benefits, and those are things that we earn over time. Social Security, when you retire, we get Social Security. The different family benefits that go with that, Medicare at 65. If you've earned your work credits for Social Security disability insurance and you get injured or ill, you'll be able to apply for those. Excuse me, survivor benefit, and then children's disability benefit. On the right-hand side are things that you need to apply for and qualify for. So you may have a disability, and the $2,000 limit of resources to qualify for them. So supplemental security income is important because that provides you this year with your child $783 a month. So I realize that doesn't sound like a lot, but it assists parents. That's one chunk of money that they don't have to look for when they're doing their financial planning. And then if a child at 18 qualifies for Social Security, SSI, when their parent retires, they qualify for disabled adult child benefit. And that means that they could qualify for up to 50% of their parent's Social Security amount. Does not affect the parent's amount, but it's an increase over their 783. And then when that parent passes away, they could get up to a 75% of that parent's Social Security amount. So that 783 could potentially approach $1,500 to $2,000 a month. That's a nice chunk of change when you're planning forward for your child to help with living expenses and support expenses. So it's definitely something to keep in mind and something that we use when we're helping families create their plans.
I would also say, Karen, if I could, that one of the other fantastic parts of that benefit are 24 months after the benefit starts, they're going to get Medicare. And, that's sort of the gold standard we're all hoping to get to if you're not already retired. So, it's not based on assets and income. And so some of those restrictions go away. So super important benefit. I appreciate you highlighting it.
No problem. Thanks for bringing that to my attention or pointing that out for the presentation. those are things that are really important when you're doing planning, because those are costs that you don't have to plan for and added income that you don't have to plan for. Some additional supports that are out there that you can apply for, SNAP, which is the old food stamps program, they decided to rename it, TAMF, and the Children's Health Insurance Program. So the one bullet that's not on here either is Section 8 housing. I have clients whose children who have applied for that. And so that's helping supplement their Social Security so that they can live, independent or semi-independent in an apartment. So these are all things that we look at as we're creating plans for families. So Emily's going to cover a bunch of the stuff, but I want to pick out a few things on this slide. When we're creating a plan, something to remember is, like I said before, we're planning for tomorrow, something happens, and we're planning for if you live to 102 and something happens. But the other thing to remember is plans, whether they be financial or legal, are moldable and changeable. So keep that in mind, that just because you're putting something in a document today doesn't mean it has to stay that way forever. So, I have parents that stress over that and say, well, I don't know what's going to happen 20 years from now. And I say, don't worry about it. Let's worry about the next 5 years. And then if you need to update your documents, you update your documents. Guardianship, I'll touch on a little bit. When your child turns 18, doesn't matter what their abilities are, the government considers them an adult. So if your child, it's a very personal decision, if your child has trouble with decision making, could easily be taken advantage of, having good guardianship of them after the age of 18 might be something that's important to you. So that's something that an attorney like Emily would be able to assist with. That is a court proceeding, so it's more of a, I don't want to call it permanent because it is revocable if you go back to court, but it's hard to change versus putting powers of attorney in place so that you can go to the doctor with your adult child or help them with their finances. But powers of attorneys can be easily changed by getting new documents and finding a notary. So just some things to keep in mind as your child gets older and decide what works best for your family. There's no wrong answer, it's just what works best for your family. We talked about titling. I'm going to talk about special needs trusts again later. And I talked about reviewing and, finding an attorney who has a lot of experience generating special needs trusts is very important. Any attorney is qualified to write a special needs trust. It doesn't mean they know what they're doing. And I always tell parents, if I can find a mistake, you're in trouble, because I am not an attorney, but I've seen enough of them. So I know when there's a mistake. So special needs trusts. Many parents, come to me and they'll go, I don't have enough money. I don't want to put a trust together. Well, do you have more than $2,000? Do you plan on leaving more than $2,000 to your child? Then you probably want to consider putting a special needs trust in place. I have other families that'll come and say, well, I have 2 other typical kids. I'll give one of them the money and they can take care of my child with special needs when I'm not here. While those sound like good intentions, they don't always work out that way. So what if your daughter Sue gets married, you pass away, she inherits your estate that's supposed to go to her and your son with special needs, and then she gets a divorce. There goes half that money with the ex-husband. What happens if Sue gets in a car accident and gets sued? There goes maybe all of that money. There's things, what happens if she has credit issues? She has to file bankruptcy. There's another problem. So, special needs trusts put a nice protective wrapper around the inheritance going to your child. So keep that in mind when you're making your estate planning decisions. The other thing that you want to keep in mind is that putting a special needs trust in place also puts your wishes down so that your son or daughter are taken care of the way you want them to be taken care of. So very important. Protects against, also helps protect those government benefits. I covered that. So this is a tough slide because parents tend to think, and I don't think they're wrong, that they provide the best care for their child because they're the parent. But unfortunately, as the parent, you're not going to be there forever. So just like I talked earlier about residential needs and touring places and getting ideas of places as your child gets older, you need to do the same thing for care provider. So if you're not here, does your child need full-time care, part-time care, semi-independent, fully independent, just some oversight? But things to keep in mind. So it's important to check out different agencies, talk to family members and see if they're willing to do that. Talk to your friends and, see if they're willing to do that. It's important to develop a plan and talk to that person so that they're not surprised when you pass away either. So keep that in mind as you're developing your plan. So the letter of intent. This to me is one of my I feel it's one of the most important documents that a family can complete. This document compiles all the details about your child. So medical, who their doctors are, who the therapists are, what medications they're on, what allergies they're on, typical stuff like that. But it also should include, does your child have triggers? Does your child have sensitivities? What their habits are, what their behaviors are, who their favorite people are. So that if something happens to you tomorrow, somebody can pick up this document and have a beginning and know where to start and know a lot of information about your child. I have templates that I share with clients so that they get started. They're done in Word so that they can be updated every year so you're not starting from scratch. I've also had clients that will do videos so that they can show examples of behaviors or favorite things. So it's your document, it's your message. I've even had husbands say to their wives, "Yeah, you really need to do this because if something happens to you, I don't know all the details. I don't know, who our contact is at DDD or what reports need to be filed with Social Security." So it's a pretty important document to complete. So how do you start the process? By contacting me or an attorney like Emily to get started. Emily and I like to work together with our clients. That way we know we're working the same direction for our clients, not against each other. But you want, like I said earlier, you want to select professionals, a financial planner that understands the special needs community and an attorney that works a lot in the special needs community so that they also understand the rules and guidelines of all the government benefits and the agencies and everything that a family who has a child with special needs has to deal with. We know your community is complex, so your professionals should know how to deal with that complexity. And how can I help? I can help you put your plan together, your financial plan for your family and for your child. Should something happen tomorrow or 35 years from now, you've got a plan in place. Help introduce you to other resources. As I said, don't try and recreate the wheel. I never claim to have all the answers, but I know people that can get us the answers. So that's always helpful. I've already done a step. I've introduced you to an attorney that works in the special needs community and helping you with different ways to fund your special needs trust, because that's different for every family. So it's important to get started. I know it's very hard for parents to take that first step because you don't want to think about what's going to happen when you're not here. But it's better to get started and put that plan in place than have that oh shoot moment if something happens tomorrow and your family's going, criminy, where do I start now? So just get started. Here's my contact information. All of you will receive copies of the slide deck when this is over. So Emily, I'm going to stop share and mute myself, and you may get started, my dear.
Sure. So we had no hands raised. So we have a quiet group. But if you have questions, by all means, put your hand up and we're happy to chat. We always feel like we're a little bit at a disadvantage. You get to see us. We don't get to see your beautiful faces and see if you're looking quizzically or you're understanding what's happening. So by all means, if you have a question, let us know and we'll go from there. I'm going to try and do my, can you see anything? Because I see nothing here.
I can see your slides, but I've got you don't have it on preview yet.
Okie dokie, let's see what we can do here.
Yep. I can see you punching the beginning button.
Can you see the slides now and not just my not correct?
I need you to flip them.
I don't know why no matter what I do, I'm always got the wrong screen up. You only have two choices, 50-50 shot, and I'm always on the wrong side.
There you go.
Thank you so much. So thank you, Karen, for allowing me to be a part of this presentation today. I think the information is just incredibly useful. Lots of people always want, free legal advice. So here I am with you for a half an hour, 25 minutes. And I've just like Karen's disclosure, for purposes of today, I don't represent anybody. I'm happy to try to answer questions on a kind of a general basis without getting into the specifics. And understanding that your questions are probably a lot more complicated than you think they might be, but I'll do my best if you have any. And that's my contact information. And again, you'll get our slides so you can reach out, and we're happy to do what we can to help. It is really important to have a great team around you. So whoever the financial planning person is, your CPA, your attorney, that they're all communicating. Because even if you think you have super simple assets and a really simple estate, you don't if you have a loved one with special needs, because you have complexities there that, as Karen said, lots of folks just don't recognize that those are complexities that need to be handled in a special way. And so we want to make sure we have the right team around you. And it is, it's great when you have a team that works well together, that can ask questions of each other, so that we can make sure we have all the answers that you might need. So with that, I'm going to talk about estate planning. So, lots of people think about estate planning as solely who's going to get my stuff when I die, and what do I do to not have to pay a lot of legal fees and taxes. But it's important to understand that estate planning is as much or more about making sure that we have the right decision makers for you upon incapacity, that we have the right decision makers in place for your loved one with special needs or your minor children, and the other vulnerable folks that are in your sphere, that we have the right people in place to help make those decisions. And of course, somebody to make medical and healthcare decisions when you are not able to make those decisions for yourself. I had a consultation this morning with a family who's working with an estate planning attorney in town, who wanted them to talk to me about the special needs piece. They have a child with who had a birth injury, and he's in his late 30s at this point, and they've moved state lines. And their understanding was that they just needed to disinherit him because they don't want him to lose his valuable Altex benefits, which is why the estate planning attorney brought me in to help them understand that we can develop a plan so that that child doesn't have to be left out, that their special needs will be taken care of. So again, having a team who can recognize, hey, this is something I know is an issue, but it's not really the thing I deal with. let me make sure that we get these folks to somebody who can concentrate on what those other issues might be. And so while I certainly do general estate planning, the focus and understanding of the special needs piece of it is also crucially important in developing what those plans are. And remember that doing your estate plan is really a gift to your loved ones. It's leaving them with the answers to questions. Anybody who has had a relative with a disability or incapacity or lost somebody that they love, having some instruction while you're going through your grief and your insecurity and your guilt about decisions and all that other stuff, if we have some written documents to try and alleviate some of that stress, guilt, and uncertainty, is clearly a kind thing to do for those that we care about. So, as Karen said, we can't really stress enough that estate planning is for everybody. Once you're 18, you're an adult. So whether that's a typical kid or a kid who has some special needs, it's just really important. I say that anybody over the age of 18 at a minimum needs a healthcare power of attorney, a living will friend of life decisions, and a financial power of attorney. Maybe you're going to have to get into that person's apartment. And without that financial power of attorney, you're not going to have the right to do that unless you're on the lease, to make those healthcare choices for that person, or tragically, sometimes making those end of life decisions. So it isn't just about not having a ton of money. It's about all the other decisions that need to be made also. One of the things that I find really fascinating, and again was brought to my attention at this consultation that I had earlier today, is that so many parents with special needs kids have some belief system that they're no matter how they do planning, if they leave any money to a person with special needs, that person will no longer be eligible for benefits. And lots of folks think, if I don't fund the special needs trust now, I don't need to worry about setting it up at all. Or I'll just do that later. I'll amend my plan later. Well, in the midst of a pandemic, I think we've realized that things can change overnight. One day you're driving to work and the next day you're not allowed to go to your office. So, things can just happen instantaneously. For those of you who maybe have a loved one who was in some kind of an accident, that as well. Like, things are fine, and then you get the bad phone call. So special needs planning is about making sure that we can leave assets to a person, to a trustee, for the benefit of a person who is receiving benefits that are based on income and or assets. So typically those benefits, as Karen highlighted, would be SSI, supplemental security income, which is folks who are disabled, don't have earned income, and have assets of less than $2,000, and they haven't worked enough quarters to pay into the system. Altex, which is the long-term care piece, and which is what funds DDD services, the Department of Developmental Disability. So you might have a child who is approved for DDD benefits, but has too much in assets, so basically gets a call from a case manager once a month, but you're not getting respite care, you're not getting vocational help, you're not getting therapies, you're not getting the ability for that person to be in a group home or have paid caregivers. So Altex is the funding piece, so we need to make sure that we're meeting their eligibility criteria as well. And you can have the trust as a beneficiary of a life insurance policy. So typically we wouldn't retitle the ownership of that life insurance as the trust, but we can definitely make the trust the beneficiary. In my opinion, that's the most efficient, best way to fund a special needs trust. The money is going to be there. How much money is going to be there. And if you have needs during your life and you spend all the rest of your money on your care expenses or the care expenses of your spouse or another child, that life insurance policy should be there as long as you've made your premium payments. So that's a really, what I think of as a really nice, safe, tax efficient way to plan for an individual with special needs. You can certainly name a trust, a special needs trust, the beneficiary of a retirement account. And while the Secure Act changed what the payouts are for children who are not disabled and are not minors, when it goes for the benefit of a disabled beneficiary, they still have their whole life expectancy. So the trustee can pull the money out, keep it in the trust, and continue to pay the bills and hopefully decrease what that tax hit is going to be. A special needs trust can be the beneficiary within your will. It can be the beneficiary of bank accounts. You can have a separate trust set up, or you can be a sub-trust of your own revocable trust. It can be a sub-trust. It can be its own trust. I mean, there are lots of different ways to set it up. Part of that is cost and part of that is convenience. But the entire purpose of the special needs trust is to protect the government benefits, protect that beneficiary from creditors and vultures out there in the world who may take advantage of that beneficiary, because we have a trustee in between the beneficiary and the beneficiary's money. So it's a way to manage it. And a special needs trust trustee has total discretion about what distributions are made. So if your child ends up no longer receiving SSI because they've converted to that disabled adult child benefit, maybe that control to make sure they have less than $2,000 outside the trust becomes less important. It won't if they're still on Altex DDD, but it still provides the financial protection for that beneficiary who might need some help managing the money and being protected because they might be very kind and very generous and want to buy things for other people if they had the money or give it away. So in general, we have kind of this array of estate planning opportunities. You can have a will. If you own something jointly with your spouse or with somebody else, last person alive gets all the money in the account. You can list beneficiaries, as we've talked about, on a whole host of assets, including your house, if it's in Arizona. You can create a trust, a revocable trust, living trust, family trust, whatever it is that you might want to call that. Or you can have the no plan, because the statutes provide us with what happens if you're on the no plan. And as Karen said, part of the issue would be that your what we call intestate beneficiaries, the beneficiaries under the statute, are going to receive those assets, even if that's not what you intended to happen. And if all of your children are not in common with your spouse, those kids are going to be entitled to half of your community assets if they're not owned jointly with your spouse. And if we have a special needs beneficiary to throw in the mix, they're going to receive that then as an outright distribution, which will put their government assistance at risk and will cause us to have to create what we call a first party special needs trust, which is the one that everybody doesn't want, because that's got the payback to the state that provided Medicaid services at the death of the beneficiary. So while you're alive and competent, you have the ability to make all these plans that are so much better than the plan that the state has for you and your loved ones. So I hope you'll take advantage of that opportunity. So we also want to think not just about where your stuff goes, but to make sure we have a document in place with regard to medical decisions. Making sure that we understand who's the one that's going to make those decisions. What decisions do you want? Because those are obviously critical. And again, the statute has a plan for you, but maybe that's not the plan you want. Maybe your sister is a nurse and that's a really good decision maker. Maybe one of your children is in the medical profession, and that would be a great opportunity for that person to be that decision maker. So, be conscientious about who it is you're choosing to make those decisions. Living wills are sometimes called advance directives. And so that's the document that says, what do I want at the end of my life? How much heroic measures are going to be important to me? Again, typically that's also called sort of your advance directive. And then we have general healthcare decision making. And for not only healthcare decisions, but mental health decisions. And of course, you're probably familiar with HIPAA authorization. So that's to make sure we can get access to your personal medical information under the federal statute. And as I mentioned, to make sure that we can have the mental health power in case you need inpatient psychiatric treatment. As I said before, I think a healthcare power of attorney for anybody who's over the age of 18 is really, really an important thing to do. You might want to look at your living will, and you may want to reconsider whether or not you would want to express a desire for assisted breathing with now that we're in COVID, because maybe you're going to recover from that. A do not resuscitate order is literally a don't put the paddles on me, no matter what happens, no matter what your age. That requires a medical professional to witness it. So that's not something you would do in in the lawyer's office, and it's required to be on bright orange paper, so you'll know if you have one or not. And it's really rare, I suppose, for a lawyer to tell you how to get free documents that work, but you can go to the Attorney General's website and they have a healthcare power of attorney, mental health power of attorney, and living will, and they're free. You can fill them out. They just require a witness or a notary who is not the person making decisions and is not related to you by blood, marriage, or adoption. We have financial powers of attorney, which are, as they say, for somebody to make financial decisions for you. Even if you have a trust, you should have a financial power of attorney, because assets such as your life insurance and your retirement accounts are not titled in your trust, and we still need somebody who could manage those. Now, your power of attorney might be effective right when you sign it, which we often do when we have spouses as the agent, or it may require a doctor or two doctors to say that you are incapacitated, and that's when they can step in. You want to be very conscientious that you've picked somebody who will not steal from you. We don't want the document to be abused where now they feel that they have carte blanche to go into your account and use money for them. That is not only illegal from a civil side, but also from a criminal side. They can't steal from you. Well, maybe they physically can, but under the statute, they have to be looking out for your best interest, acting as your fiduciary like a bank would to the person who they are managing the money for. My point is, don't just pick your oldest kid to be your agent or your successor agent. Pick the right person. Your child who maybe has issues with their own money is probably not going to do better with yours. So pick the person that you trust. And maybe it's outside your family. Maybe there's a niece or a nephew or a cousin who's really a better choice for that role. Karen touched on guardianships. So you can nominate a guardian in your will or by a separate nomination document. I think this is really important, and I really like a separate nomination, because if something happens to you, the person who you've nominated on that form would then be able to submit it to the clerk at the probate division with a couple of other documents and would be appointed right away before we have to have a hearing and do all the other stuff. If it's in your will, the will has to be submitted, but part of the issue there is whether or not the clerk will agree that it is a valid living will. If there's any issue with it, you're going to have a delay in when somebody's going to be appointed to be the guardian. So I really like that separate nomination form. Also, it's much less expensive if you have to go back and see the lawyer to have them change out the names in your nomination form than it is for them to amend your whole will if you've changed who you wanted to be the guardians. I suppose you might need to update your will for other purposes if you're changing the guardian. Maybe you're also going to change the personal representative or executor and maybe some of your beneficiaries. But just so you understand, there are some options to make sure you have somebody in place to take over for you.
Emily,
Yes.
back to that slide. Is that for over age 18 or under age 18 or both?
So you can do the nomination of guardian for a minor, somebody who's under the age of 18. You can even do this form if you have a spouse who's disabled and you want to make sure that the appropriate guardian is chosen for them. Or it could be for a person who is an adult and disabled or special needs child who's already turned 18. The issue would be whether something needs to be submitted to the juvenile court if we've got a minor, or to the probate division if we have an adult. So it's more where it gets filed than it is who you can have that authority to appoint. Thank you for the question. Very important to understand how your assets are titled. It's a conversation we always have when we're doing estate planning. Lots of people don't remember, did I put it in the trust or is it not in the trust? Is it joint? Do I only have my spouse as a beneficiary, or do I have contingent beneficiaries? Did I name my special needs child as the beneficiary? It's going to go in, 1/3, 1/3, 1/3 to my 3 kids, not realizing that I have a child who I need to make different arrangements for. Um, you know, have have you provided enough information to your decision makers so they know what to do, what's available, how much there is to help people out to when they're making decisions about the financial piece of this? I recommend everything go in a binder. As Karen said, your letter of intent can go in there. So your instructions for, they like the lights on, they don't eat peas and carrots, they don't like frozen vegetables, whatever it might be, how small or little that is might be a huge trigger for that child. It might be really, really important for those people to understand what those triggers might be. I am old and I like paper. So within that binder, you can certainly do a fancy financial statement, but maybe just the first page of each asset you have, every single bank statement, and the copy of the beneficiary form for your life insurance and your retirement accounts, so that we know what we're looking for. We have a whole account number. We know how it's titled. We know who the beneficiary is, because the companies are only going to respond to the person who's entitled to the money. So if you send a notice in of mom died, I want to collect the life insurance, but you're not the beneficiary, they are not going to respond to you. So those beneficiary forms, having them available and where the decision maker knows where they are, is really, really important. So guardianship is a court action. You can take away some or all of a person's decision-making authority. And so you can do a limited guardian so that they can continue to vote and drive as long as you have enough evidence that will meet the statutory requirements. And it basically keeps you in the role of parent if you're talking about your child. Guardianship is not over the money. So if you're the rep payee for Social Security benefits, you would remain the rep payee because that's your role, and that's completely fine. And guardians can manage up to $10,000 of assets. So if your person has a small account, they have, $1,500, you can still be the guardian. You don't have to become a conservator, which is somebody who manages money. A guardian is also not the trustee. People get super confused sometimes. The way that I like to think of it is, you might be a mom and an aunt and a cousin and a grandmother and an employee. So those are all words that mean something different depending on what your role is, but you're still you. I'm still Emily, even though I'm in all those roles. So you might be the guardian, you might be the rep payee, you might also be the trustee. So understanding what your role is and what's important to what authority do you need. One thing that I don't have a slide for, but I think it's important in this context, is kind of one of the final things I want to talk about, is that you can file for guardianship when your kiddo is 17 years and 6 months. That is the earliest you can file, unless you're in juvenile court. Typically, you're in juvenile court on a guardianship because the parents are incarcerated, deceased, not able to care for that child any longer. But you're in the probate division if we're talking about a kid who's 17 and a half years old or older. Recently, I've had a bunch of parents call me panicked that they're not going to be able to get this all done before their child turns 17 and a half, and that they feel that they can't file for guardianship. That is a starting point. You can't file for guardianship of your own child before 17 and a half. It will become effective on their 18th birthday. It's just that the court won't hear the matter if they are younger than 17 years and 6 months, and you have all the authority you need. but you can file after age 18, after 20, when they're 100. You're already in the the adult system within the probate division. We don't have separate, well, we have a couple of separate rules, but not very many separate rules for those kids who are just turning 18. So don't feel that you blew it because you didn't get there in time. And understand that it will take about 6 weeks to get a hearing date and get you appointed. So if you want to have authority prior to their 18th birthday so that you don't have a gap in time, it is important that you understand that it won't just happen overnight when you submit your papers. There are a lot of steps, guardian, you have to get court appointed counsel and a hearing date and a court investigator, and a lot of work has to happen. So just make sure you're thinking about that at the appropriate time. So I want to make sure we have time for questions, because as Karen knows, I could talk for days on these topics. So I hope that's been helpful, and I really appreciate the opportunity to be here and to help answer questions.
Thank you, Emily. We'll take a few minutes. Does anybody have any questions for Emily or myself? Again, you can raise your hand, hit the raise your hand button, and then I'll unmute you so you can ask your question.
So while we're waiting for that, one of the issues you brought up, Karen, was, if you could file for guardianship or maybe do some kind of powers of attorney. And it's a really great point. And I think that one thing that parents struggle with is, what should I do? And I don't have an answer, and Karen doesn't have an answer. I think you have to talk to your doctor, the psychologist or the neuropsychologist or the therapist that they're seeing, and determine, do I think that they are able to make these kinds of decisions, or do I need to make them for them, taking into account what they want? Because anybody who has kids, I think, would say, well, any 18-year-old probably still needs a guardian. So it's really thinking about, do they have the cognition and the executive functioning to be able to make their own health and housing decisions? Because understand that a healthcare power of attorney doesn't take that authority away from them. It adds you on as the agent to help them make those choices. And as Karen also said, even though it's called a permanent guardian, it can be terminated as soon as we have physician evidence that the person is no longer in need of the guardianship. So it can be terminated later as they mature and as they're more able to make those choices. So definitely important things to think about.
Most definitely. I think that helps parents ease their minds that, they can change things, whether it's guardianship, whether it's your documents, whether it's the plan that I help them with, doesn't matter. Things can be changed.
Absolutely. Absolutely.
So we don't have any questions. So I'm going to say goodnight and thank you for attending today. Emily, thank you for your time.
Thank you so much, Karen, for having me and setting this up.
Take care.
Bye-bye.